Hello everyone, welcome to EduCare 247. This is the fifth lecture of Industrial Relations and Labor Laws. This topic is very much important for UPSC EPFO 2020 examination. In our fifth lecture, we will be discussing the labor laws issues and COVID-19. In the news, you must have seen the migrant laborers are moving to their home states, and many states have amended the labor laws related to their states. So we will discuss why the states have done the amendment, what will be the implication on Indian economy, and what will be the implication on overall labor market. So this topic is going to be very important for your upcoming examination, so pay attention. EduCare 247 has launched UPSC EPFO 2020 comprehensive course. In this course, we are covering the detailed syllabus. We'll be providing 10,000 plus MCQs, 12 mock tests will be there. Our content are crisp and concise. Live doubt session will be taken to destroy your doubts. You can use the code EPFO to get 1500 rupees discount. So right now the course fee is 1499 and this is Corona discount, so you can use this coupon code EPFO and get the discount by visiting our website educare247.com. Let us understand the changes in labor laws and how it is related to COVID-19. The COVID-19 pandemic has triggered the public health and global economic crisis. You must have seen in the news how our public health facility is facing challenges because of COVID-19, and globally overall economic activity is shut down, so all the economy is facing the crisis. Employees and firms are uncertain how they are going to revive from this crisis and how the economic activity will pick. Recently, some state government has decided to make significant changes in the application of labor laws. These changes are being brought about to incentivize the economic activity in several states, but this move may undermine the interest of laborers. Laborers are the most vulnerable section and they are most impacted by this pandemic. So we don't know these changes will benefit the economy or not, but one thing is certain, the laborers are going to face certain challenges because of this changes. Madhya Pradesh has allowed units of business and industries to operate without many of the requirements of the Factories Act. So basically companies and industries don't have to follow the Factories Act and they can start their activity without following the Factories Act. Uttar Pradesh government has cleared an ordinance exempting business and industries from labor laws. Only few industries have been kept under the labor laws and rest has been exempted for period of 3 years, and many states are planning to change similar measures. So this is going to impact drastically the overall labor market. Let us understand some major Indian labor legislation. Labor falls under the concurrent list. It means on this topic center and state both can enact the law, but if center and state both are enacting a law on a similar topic, then center law will surpass the state law. There are 4 major central legislation which most of the company follows in India. So the first is Factories Act 1948. The objective of Factories Act is to ensure safety measures on factory premises, promote the health and welfare of workers. So this is one of the most important act for the labor reform, and Madhya Pradesh has allowed the industry to operate without the provision of Factories Act 1948. The second important legislation is the Shops and Commercial Establishment Act 1961. It aims to regulate the hours of work, payment, overtime, weekly day of pay, another holiday with pay, annual leave, employment of children and young person, and employment of women. So this is also a very significant labor legislation. The third important act is the Minimum Wages Act 1948. It sets the minimum wages that must be paid to skilled and unskilled laborers. So point to be noted, this act is applicable for unskilled laborers as well. The fourth one is Industrial Disputes Act 1947. It reflects to terms of services such as layoff, retrenchment, and the closure of industrial enterprises, strikes, lockouts. So basically, it talks about the labor rights. What will be the service condition for the employment, strikes, and other closure of the businesses? What will be the criteria for those things? So Industrial Disputes Act talks about these things. So these are the four important labor legislation, and that is very much important for your upcoming examination. So keep these acts in your mind. Now let us understand how the recent change will impact the laborers. The first one is creating an enabling environment for exploitation. See, the immediate suspension of labor laws by the state is far from being called the labor reform. Now we talk about reform, but if we are suspending the labor laws, it will strip the labor of its basic rights and also drive down their wages, because company are no more liable to pay the minimum wages. So overall wages will go down and they will be prone to exploitation. The suspension of act, most of the provision under Factories Act 1948 and the Industrial Dispute Act 1947 would mean the workers in factories may be denied basic working facilities such as cleanliness, proper ventilation, drinking water, canteens, and restroom. So this situation is going to be very challenging, because if the laborers are working at unsafe place, it will impact their health, and that is a bigger challenge for overall economy in the future run. These recent change in labor laws may be counterproductive. Why? Because right now those who are working in formal sector, they can become the informal workers because they will not get any social security. So basically it is far from pushing for greater formalization of the workforce. Also, there will be no way for any worker to even seek grievances redressal, because there will be no grievance redressal mechanism. It will result in falling the wages, and that will impact the overall demand in the economy. So basically in a long run it is going to hurt the economy rather to revive the economy. The next major impact will be forced labor. How? First, you understand Article 23 of the Constitution prohibits the forced labor. And what is forced labor? In the Supreme Court case of 1982, Pudur versus Union of India, the Supreme Court has defined the word force. Basically, it would mean any condition arising from the compulsion of economic circumstances which leaves no choice to alternatives to a worker. So basically, if economic condition in such a way worker cannot leave the job, that will be called the forced labor. Basically, the suspension of labor laws by several states reduce the bargaining power of the labor, their right to negotiate, and hence may turn them into the forced labor, because there will be crisis for the job in the market and companies are not paying according to the minimum wages, so and they are bound to work, so they will be like a forced labor. The another important impact will be it is against the international commitments. So basically these amendments in labor laws are against the spirit of International Labour Organization's Employment and Decent Work for Peace and Resilience Recommendation 2017. What this recommendation say? This say it requires state to ensure marginalized group freely choose employment while rebuilding after any disaster. But here state is doing the opposite. They are not protecting the marginalized group, they are protecting the industry, and it will hurt our image on the global level. Hope you have enjoyed the video. If you have enjoyed the video, like, share and comment, and thank you and happy learning.